SJC-13391, Commonwealth versus Donovan E. Goparian.
Mr. Schnipper, good morning.
Good morning, Justice Gaziano. May it please the court. I'm Merritt Schnipper here today on behalf of the defendant, Donovan Goparian. The Brady violation in this case was egregious, both in terms of the initial nondisclosure and in terms of the prosecutor's failure in his duty of inquiry upon receiving the Richardson email. Billy McElhenney is not some random third-party culprit possibility. He's the defendant's nephew, one of the Commonwealth's main witnesses in the case against Mr. Goparian, and of course, he's a demonstrated participant in events surrounding the burning of Marie Martin's car. And Vito Nozzolillo is not a random or anonymous source. He's someone that federal agents who conducted his proffer confirmed McElhenney lived with at the time he made the withheld admissions.
This may go to the failure to have a hearing, but we don't know because there's a proffer, but then there's no affidavit, and then, of course, because there's no ensuing hearing, we don't know what the Vito Nozzolillo. We don't know what he's going to say.
Well, I did provide the court with an affidavit in which he adopted his statements in the proffer report, and I feel that's plenty to show what he would have said. I mean, I could have written out what was in the proffer statement and had him sign that, but the reality is that's the contemporaneous record of his statements. And I agree, because we didn't have an evidentiary hearing, we don't know specifically what he would have said. And we can say with likelihood that he would have said what he said in his proffer report. He might have said quite a bit more, and he might have crumbled under cross-exam, or he might have stood up brilliantly. But we don't know, and the reason we don't know is because the Commonwealth prevailed on not having an evidentiary hearing. And I think because we don't have an evidentiary hearing, there's a lot of other things we don't know about what happened in Mr. Nozzolillo's proffer, and of course not only about what happened at his proffer, but about what the Worcester Police Department did or did not do in response to the information it received.
You obviously you allege error in not having a hearing, and then
I definitely do, as well as not granting us our multiple motions for post-conviction discovery, because without a hearing and without post-conviction discovery, there really is no way for the defense to penetrate what happened in terms of the prosecutor, the police department, the federal agency, and the witness, and what happened in this proffer statement, right? So there's no doubt that this is a knowing and willful violation of Brady, and it's not just a violation because they didn't forward the email that was sent by Detective Richardson. It's a violation because upon receipt of that, it's quite clear the court went through it in Graham versus Hampton DA, but that is not new law. That's a summary of longstanding law that's both federal and state law. They had a duty to inquire, bounded only by reasonableness, to find out what was there. And what was there at minimum is the information that's contained in the DEA-6 report. That's the minimum that was there. Now, what we don't know is whether the police department ran down any of the leads that Mr. Nozzolillo gave them. What we don't know is whether, for instance, there was a search in this pond where Mr. McElhenney said he threw the gun, and of course the gun in this case was never recovered. So there's a lot that we don't know, and frankly, there isn't anything more that the defense could have done to show the Superior Court that we were entitled to know this, right? I mean, I come to the court for post-conviction discovery based on what happened at trial, right? I'm denied on the representation from the Commonwealth that they have nothing responsive. I get the DEA-6 report, I renew my motion, I'm denied once again. I then spend 2 years engaged in a public records process. I obtain the Richardson email that shows without question that the Commonwealth had responsive materials, had notice of the proffer. I'm once again back before the court asking for discovery. I'm denied again. I say, Judge, I'm at the hearing, the non-evidentiary hearing, basically pleading with the judge, saying, please help me. Please order certification that the files of the Worcester Police Department have been searched for this material, and I'm just denied. So there isn't anything more that we could have done than we did do in the Superior Court to obtain whatever information we do have. But what we do already have and what we're able to bring before the court is absolutely devastating, because we're certainly entitled to the more favorable substantial basis standard of review. This is a knowing and willful violation of Brady. It's withheld in the face of a specific request as well as in the face of mandatory disclosure obligations under 14A1A Romanet 3, right? So that's all there. But when you look at the specific issues of trial prejudice, it's astounding how it pervades the case, right? And I think I'd like to go through a bunch of them, but the most potent to me is when trial counsel is attempting to cross-examine Heidi Thompson about whether Billy McElhenney had access to guns. The Commonwealth objects. Of course, the Commonwealth knows that they're withholding statements about his access to guns, or at least his access to one very important gun in this case.
The part where the purported witness says that he was responsible, Billy says he's responsible for the murder, that was that was an admission by silence, right? He goes,
For the killing itself, he said, "Did you kill this woman?" And he just hung his head.
he hung
That's
his
what he
head,
said.
right, but the other ones, as far as the vehicle and the firearm are part of the...
Expressly admitted them over a
That's part of
course
the
of
proffer.
several conversations while he was living with Nuzzolillo at the apartment that, of course, the federal agents were monitoring at the time that they were investigating Nuzzolillo. So the federal agents are able to confirm at least that McElhenney was with Nuzzolillo for a period of months where these admissions could have been made. But when Mark Shea, defense counsel, goes to sidebar to argue the Commonwealth's objection to... it's amazing. He says, because right before trial, Heidi Thompson finally says, I took Billy McElhenney to buy gasoline the night that the car was burned. Well, that's really something. But of course, Mark Shea doesn't know at the time that Billy McElhenney made admissions to burning the car. So he's up there saying, Judge, now that we understand that Billy McElhenney is getting the gasoline and burning the car, we see that he plays the entire role that the government is saying Goparian could have played in this entire case. We don't know who shot this woman. So he's feeling his way towards exactly the information that is being withheld. That's because he knows something is wrong with this case, right? All these people are mixed up in something crazy going on.
Just so I make sure I understand, Thompson testifies. What does Thompson say Billy, whatever his name is doing about burning the car and other things? She testifies. I know she's testifying that they're driving around together, right?
Oh, so she testifies.
I'm just trying to figure out the difference between what she testifies to what we learned from, whatever this guy's name, the federal informant.
Mr. Nuzzolillo is the federal informant, and McElhenney is the trial witness.
I know the difference, but I'm trying to understand. Thompson testifies to Billy doing certain things.
So she testifies to Mr. Goparian burning the car. Right. She testifies to them going to the McElhenney home.
Billy is not at all. Thompson's testimony doesn't put Billy at the burning scene, the scene of burning the car at all.
He does not. She says that Mr. Goparian and herself.
Nor does Hogan do that either.
That's correct, right? Hogan is the one who drives down to Worcester with Marie Martin. He's the one who's present there, according to his CSLI data. He's shown on video there. Obviously, it's only his testimony that places Mr. Goparian there. Of course, Mr. Hogan's testimony is significantly compromised both by the fact that he's the initial suspect in the case and the person with an astounding level of connection to Ms. Martin and her life and her death, but also that, of course, the rest of our post-conviction investigation, the part that doesn't flow directly from the Nuzzolillo proffer information, is all focused on Tom Hogan, and it shows both that he's the person who possessed a firearm that's most likely of the firearms in the universe of this case to have fired the bullet that's found in Ms. Martin's head.
I don't get, I mean, you've got a big Brady violation, but with the firearm, just to, I guess, to sidetrack you just a little bit, I'm sorry, but the violation I see is the weight of the projectile, right?
Well, I think
it's a 71 grains, correct?
Well, that's certainly a violation here, but it's our position that we've established at least a prima facie case that justified an evidentiary hearing on whether the Commonwealth has provided any firearms discovery in this case.
Well, we have a firearms report, and then there's a note that's later discovered,
So there's a
the note of the ballistician, and the ballistician's note says what the grains are, but you have the projectile.
You do have a projectile.
So it doesn't take a rocket scientist to weigh it or to figure out if the defense hired a ballistician, they have the particular projectile, they could weigh it themselves. And every ballistics report I've ever seen, it shows the grains of the projectiles are recovered.
Sure. So this one doesn't. It only shows
the
caliber.
Right, but it's not exactly shocking that they would weigh a bullet and tell you what the grains are.
All right, well, let's assume for purposes of argument that it's not a newly discovered analysis because it was available before trial if the decision had been made to go and inspect the bullet and follow that up, even though, let's also assume, because I think we have established a prima facie case, that there was no firearms discovery provided. The question of whether it's newly discovered is only one of the questions the court has to answer, because under well-established Rule 30 case law, going from Grace up to Rosario and the present, even if it's not newly discovered, it needs to be considered in the context of the entire case with evidence that is newly discovered. And what it shows what it shows is that if Mr. Goparian supposedly possessed a .32 revolver that he would use, he would modify bullets with rubber O-rings and shoot them out of that revolver. Well, when Lewis Gordon performed an analysis, he did that with both a .38 revolver like the one seized from Hogan and a .32 revolver like the one Mr. Goparian.
But this was available to you.
It's available, but I still think it's important.
The same with the medical testimony, right? Because I see that as late discovery as far
I'm sorry,
as
with what?
what you argue with counsel about is whether or not this is late discovery or newly discovered testimony regarding whether or not the person would have been alive to give right? So I read the request for a continuance, and I don't see anything where defense counsel, although he submits an affidavit later, says to the judge, I need a continuance because I've got this fantastical evidence that the person was shot in the face and they said something, and I need a continuance to go hire a medical expert to figure out whether this is plausible.
He certainly does not go into that depth, but if you look at the January 29, 2020 transcript at page 5, he says, I just received 2 new reports last night, and I'd like a continuance so I can investigate them.
He goes, I'm renewing my motion to continue based on these 2 reports. And then later on, he doesn't say anything about a medical expert.
No, he doesn't. But
and then later on, he says, the judge says the significance has to do with the antique firearm. And then the judge says anything further relative to the continuance, and he says no.
All right, so you've quoted the transcript correctly. But what I'm saying is that he says I'd like a continuance based on 2 new reports. The 2 new reports are the O-rings and the
But you should have brought it to the judge. It's late discovery, but it's as opposed to newly discovered. So the judge should have been on notice that, because if I'm sitting there as a trial judge and someone says to me, I just got this testimony, this cries for expert review, and I think a judge should say, because of that, you get your continuance.
All right, well, I think the judge should have said that too, but this is what I'd like the court to focus on, all right? He asked for a continuance based on the 2 new reports. It is true that the dying words is one of the 2 new reports, right? He doesn't focus on them in his argument to the court. He then says, and of course, that doesn't change the fact that this is likely false testimony as shown by Dr. La Posada's affidavit, and I think that's worth the court thinking about regardless of newly discovered status. But what he does say is he has an affidavit that says, if I got the continuance, I would have done this. And you know what? The government says we will stipulate to the truth of that statement. And the reason we will do it is that we want to avoid an evidentiary hearing. And the reason we want to avoid an evidentiary hearing, of course, is that a criminal defendant can't win a Rule 30 motion without an evidentiary hearing in the Superior Court. So that's a tactical play by the Commonwealth, and they won. So that's a perfect situation in which judicial estoppel applies because they took a position below.
And I'm not saying under Brescia in all those cases that we don't consider everything that happened along with the, I think, blatant Brady violation to begin with.
I agree with you. So, it all has to be considered.
I would hope you would agree with me.
It's certainly a blatant Brady violation, but what's going on here is there's just a swirl of noncompliance. So it's really hard to figure out, particularly without an evidentiary hearing, what actually is going on. I would like to revisit the question of nondisclosure of firearms evidence because, what I've come forward with is my own affidavit reviewing the file and finding no firearms report, not the handwritten notes. Mark Shea's affidavit, he has no recollection of seeing them. And of course, 0 discovery compliance certificates filed by the Commonwealth during the pretrial period. That adds up to a powerful prima facie case of nondisclosure. The way to explore that and to rebut that is to have an evidentiary hearing in which the Commonwealth was welcome. And I said they don't want to cross-examine Mark Shea. When November 21st of 2023, when we're talking about an evidentiary hearing, I say they don't want to cross-examine any of these witnesses.
In your review of the record, there's absolutely no ballistics report.
There's no ballistics report. And so that's why I called up the trial prosecutor and I said, could you please provide it to me? And he was courteous, and he did. It took 90 days to get it from the state police. If he had produced it in pretrial discovery.
So the defense attorney goes forward in a case involving this incredibly strange scenario of the caliber of bullets, and you're telling me they went forward without a ballistics report?
I'm not telling you that he did or didn't do anything. I'm telling you that we've established a strong prima facie case that that's what happened, and the way to explore that was at an evidentiary hearing that we more than abundantly satisfied the requirements for holding. That's what I'm telling you. But what I'm also telling you is that when you flip around to the substantive part of the firearms analysis, the gun that is most likely to have fired the bullet that is taken from Ms. Martin's head is a .38 caliber revolver. And the reason for that is that Lewis Gordon, who's a very well-respected ballistician in this state, does an analysis of both a .32 revolver and a .38 revolver firing a .32 automatic round, which is the exact type that came from Tom Hogan's home. And he says the .32 revolver, it's not perfect, but it engages with the lands and grooves and has striations. There's random markings on the .38. That's the similarity.
He doesn't do this. He doesn't do what most ballisticians do and say that they're a match and the like.
There is no match, yeah.
He says the striations. So I
But
take
what
that as
else
far
he
as it
says,
goes.
which is, I think, rather remarkable and very relevant to this case, is that he says, when I measured the velocity of the mismatch fire from the .38, it came out of the barrel at approximately 70% reduced velocity as to normal firing. In other words, it was moving at only 200 feet per second rather than between 700 and 800, which is the expected velocity. And Dr. La Posada says that's entirely consistent with and explains how a person was shot from close range in the face and still has a bullet that doesn't even penetrate farther than just through their cheekbone.
Justice Gaziano is happy on fire. I'd like to better understand the third-party defense and how it was prevented here. So what was the theory of the defense in the case? Was it that one of these guys, Billy or Hogan, did the killing?
It's basically just that there's absolutely no way to know who did the killing, and that Tom Hogan is completely tied up in the case, and that everybody else has motives to lie.
And it's not, and this suicide idea is that, I haven't had a chance to read the transcript. I'll be honest, the briefing raised so many legal issues, I didn't get beyond that. So,
I think if I hadn't even gotten more words, I could have given you more arguments.
I read the brief, and the alternative is that we've got this suicide theory where she wants to kill herself. Is that any of that present in the trial? You know, this idea.
Sure, there's a ton of it present in the trial. There's obviously there's a bunch.
Some of it's excluded, right?
Yeah,
You
some
say
is
improper.
excluded.
The
But she's
stuff from the ex is her ex is excluded.
Her ex is excluded on the question of when he's first told of her passing, he says, well, she's had suicidal issues before. That's what he says to the police.
Right.
And then he's also prohibited from testifying. He runs an insurance agency that because of her mental health issues, she couldn't get life insurance.
Okay, so
So I'm sorry.
Go ahead.
So the suicide theory is she wants to set up the ex.
Yes.
And then she shoots herself in the face, and then she has a friend dispose of the firearm and
Not
burn,
that she
and burn her body.
that he shoots.
Well, no, that's not our theory. I mean, because there's absolutely no witnesses to any of this, it's anybody's guess what actually happens. The only evidence that Mr. Goparian is the one who shot a gun at her comes up at the very end of right before trial, when all of a sudden these witnesses who have been cooperating with the government
Given
for
the
2 years.
disposal of the body, suicide seems like a far-fetched theory and not
Well, I'll say two things about that.
deserving of an instruction by any stretch.
All right, well, if you don't feel that way, you don't feel that way. But, as far as I'm concerned, in the light most favorable to the defendant, especially given the lack of credibility of the people who came forward at the last minute to say he shot her, I think that light's most favorable, he does get it. But frankly, between Brady and newly available evidence, we don't need a manslaughter
I don't think the
instruction.
manslaughter is your strongest argument.
I'm not advancing it as our strongest argument, but my job is to be a comprehensive presenter of all the issues in this case for 33E purposes. So I chose to present it because I certainly don't think it's frivolous, but I accept your position.
Your primary argument is that the federal informant would have pointed out that Billy is the guy, and you weren't allowed to develop that because of the disclosure violations. You would have had a lot more evidence to prove that, right?
We would have a tremendous amount of more evidence to prove that, both because we would have had his own admissions to confront him with, and we would have been able to weave those admissions together with Heidi Thompson's independent statement right before trial that, oh my God, I just need to tell you that I took Billy McElhenney to buy gasoline the night the car was burned. So all of a sudden, it's not just, we don't just have Mr. Nozzolillo's statements. We have Heidi Thompson's statement saying that she took Billy. And then, of course, there's a ton of inconsistencies between Thompson and McElhenney about the night that the car was burned.
And can I'm just, again, because there's so many moving pieces, I'm having trouble connecting.
No, it's a complicated case, for sure.
And Hogan, the gun, the ballistic evidence that you're focused on is connecting it to Hogan, not Billy, correct?
That's right, and you're echoing a point that the Commonwealth has emphasized. Well, your defense is in disarray. You're pointing at Hogan with a gun and McElhenney with a gun. My response to that is, yes, we are. Our job is not to solve this crime. It's to create reasonable doubt about whether Mr. Goparian committed it. And when you have two individuals definitely implicated in all the surrounding acts, both of whom had access to firearms, neither of which the government did a meaningful investigation of. And of course, counsel is pursuing a Bowdoin instruction, obviously not given, but that's one of the themes of his defense.
When you strip away the case to I think its essence, we have a trial judge who we have to give deference to, who basically says that, assuming all this Brady violations, although he says it wasn't in the custody and control, which I think is not correct, but anyway, strip that away. He says the evidence was so prejudicial that it doesn't matter. What's your response to his points that he raised?
Sure.
For lack of prejudice by the Brady
Well, I just think that
violation?
if you're going to claim overwhelming evidence, this is a testimony only case. There's not a shred of physical, forensic, video, anything connecting Mr. Goparian to this crime. The only meaningful substantive testimony comes from these three witnesses, all of whom are hopelessly compromised by our post-conviction investigation. And what's important about the way they're compromised is they all just kind of say, oh, and then he just made these admissions of killing her. But what makes their testimony meaningful is that they're part of his life and they're testifying to the surrounding events. But especially with Thompson and McElhenney, but to a lesser extent with Hogan as well, their testimony to the surrounding events is shown to be completely incredible by the fact of their own involvement, or at least putative involvement based on their pretrial statements about in burning this woman's car with her body in it.
Any good comparative cases you would point us to where a judge relies upon purely testimonial?
I don't have a case for you, but I just think that the bottom line is, like, the judge sat, right? Obviously, he was convinced by the evidence, but we just have to look at when a witness's testimony is weakened, right, by external evidence that's produced, what we do is look to corroborating things that don't depend on that witness, whether that's forensics, video,
What about
fingerprints,
the phone? Excuse me. What about the phone records?
Yeah, the acoustics are
I'm
strange.
sorry.
What about the phone records?
Well, the phone records, obviously, they're obtained without probable cause. That's our position. But the only thing that phone records show, in terms of the track phone, the 2470 number in Mr. Hogan, is that they're in contact a ton.
But the defendant is also in touch with Hogan.
Yes, well, nobody's claiming he doesn't know Mr. Hogan or they didn't contact him. I mean, again, accepting that evidence is properly before the court. We're not suggesting that he didn't know Tom Hogan. We're suggesting that a story is being told by other people who are implicated in this crime to point the finger at this guy, right? And the phone records, all they show is contacts. They don't show any substance of the nature of the communications. And at the operative times, all the communications are between Tom Hogan and Ms. Martin's, burner, her track phone. And we don't have a time of death, right? Tom Hogan goes down there at 3, her body shows up in a burning car at 10.
But we also, the defendant's phone was off for 4 hours at a crucial moment. And if Hogan is there killing her, he wouldn't be calling her on the cell phone.
Well, who knows what happens? And the point of our entire presentation is that there's a ton of reasonable doubt here if the case is properly presented. So what Tom Hogan says when the police first confront him about her death is, there's a log of stuff. She's been feeling threatened by her boyfriend. Like, when he is first confronted by the police with her death, he's putting into effect a plan to blame her boyfriend for her death. That's what he's doing. He says she has a log of stuff. He says she was feeling threatened by him. She is doing this weird thing where even though she has an existing trespass order against him, the morning that she dies, she's going to the police station to ask for a new no trespass order against him. There's a lot of reasons to believe that something very bizarre is going on here. And Tom Hogan is obviously very caught up in it. So to say that the phone records, what do they prove?
Well, you had just asserted that the only evidence was his testimony, and it seems like there are also phone records, and there are also the observations of the car that was used by the defendant going to and from the site.
Those observations are in a search warrant. They're not testified to at trial.
Oh, that's helpful to know.
So that's one point. But there's phone records back and forth, but they just don't establish anything that people are in contact with. And if you're going to take witness testimony that's shot full of holes like this and say the fact that there's no available GPS information from somebody's phone for 4 hours is enough to corroborate this and send someone away for life without parole, I just don't think that can stand up.
I understand that the strange detail about the candles was excluded from trial.
No, it was in there.
Oh, I thought that the candles and the mat notes.
Yeah, so those were the responding police officers who did the initial response to Ms. Martin's home found those candles burning, and that was admitted.
That was admitted,
Yes.
and there was no other evidence in the record relating to any investigation as to who lit those candles.
No, certainly not. I mean, I guess the assumption is because it was in her locked home that she had, but that's only just an inference from the fact they were found in her home burning.
And Billy, what's Billy's connection to the victim? Does he have a personal I'm just trying to.
It's not clear.
It's not clear. So
No.
Hogan knows the victim because he works for Busio.
Well, he works for Ms. Martin. He worked for Mr. Busio for a number of years. Then he is introduced by Mr. Busio to Ms. Martin. He becomes Ms. Martin's handyman and kind of hangout buddy, and he then obviously stops working with Mr. Busio, at which point he participates in cooking up a plot to have him severely beaten or killed. And then
Hogan does, but
Hogan does, yes.
But Billy, whatever his name is totally unrelated to all this. His only real connection is to your client, right?
He's his nephew, but he's a person who's part of Heidi Thompson's life. He's part of the entire circle in which these people live.
I'm just trying to get the big picture.
Sure, the big picture is
Can
that.
I ask you one question more for all the stuff you've got on the gun? Your guy doesn't come out and say that the gun in Hogan's house is the gun, right? I'm just trying to
he
understand
makes
what
no
it
statements at all.
what it all. So the gun, I'm just trying to understand the overall significance of the ballistic stuff.
Sure. Well, there's never the gun is never found.
Gun is never found.
The bullet itself does not show signs of it being shot by the type of gun for which it is designed. So it's a .32 automatic round, and when it's fired from a .32 automatic pistol that Tom Hogan has, obviously that has close striations, just like what we call lands and grooves marks, the standard stuff. The murder bullet does not have any of those marks. It has random scratches on it. Right. When Mr. Gordon so they seized 4 guns from Tom Hogan's home, but the police only test fire the .32 pistol. But when we, post-conviction, say, let's test fire with an O-ring on it, one of these pieces of ammunition out of a .38 revolver, just like the one seized from Tom Hogan's home, it comes out with markings that Mr. Gordon says are very close to the markings that are on. And of course, they wouldn't be perfect replicas because these are randomized markings.
The trial testimony is that that your client got the bullets from Hogan.
That's actually not the trial testimony. It's certainly suggested by the Commonwealth's evidence. There is never actually any testimony about whether Mr. Hogan provided ammunition. He says they had talked about him providing ammunition in a pretrial prep session. He denies giving any ammunition to Goparian, and I think that's very important when the court thinks about the overall justice of this conviction, because the bottom line is there is no other source of bullets available to Mr. Goparian, at least that we know of in the record. So the fact that this is a perfect match by caliber and weight to Mr. Hogan's home, and he's the only one who has access to it, and he's the one who has access to a gun whose test fires bore the closest resemblance to the bullet in Ms. Martin's head, in a case where no firearm that was used to shoot her was ever recovered, I think is pretty powerful evidence.
And you've got the fact that the federal informant said that Billy just got rid of the gun, so that helps you also.
Yeah, and not only that Billy said that he got rid of the gun, but that there's no evidence at all that the police decided to go look at this pond, which is right down the street from where Billy says he smashed the gun, and figure out whether there were any pieces of a gun in that. And of course, that's the case, even though they never found the weapon, right? So and of course, and the truth is, we don't know whether the police investigated that, because we've been denied any discovery from the Worcester Police Department's files about anything they might have done. And we cannot simply, frankly, in a first-degree murder case, accept Commonwealth Counsel's representations that there's nothing there, especially not when those representations were proved to be inaccurate by my public records work, which turned out that 2 years after he had said, we don't have anything, I got the email. I mean, I just don't think, deference to a trial judge is one thing, and letting him sit there and simply deny me access to evidence that I have more than established entitlement to is another. I just don't think deference gets us that far. The bottom line is we built a post-conviction case that justified discovery. We built a post-conviction case that justified an evidentiary hearing. We were denied that, and largely because the Commonwealth chose to stipulate to the truth of those affidavits, right? That's the position it took, right? And that's why we're here without a hearing. because the Commonwealth didn't want to cross-examine Mark Shea about any of those things, didn't want to talk to Louis Gordon about his analysis and what it showed and what it didn't show, didn't want us to have a hearing where he would put up slides of micro photos of the bullets that he had used, and he could have explained the different ways that a .38 does or doesn't engage. None of that was wanted to be in the record. But what that does is builds a comprehensive case where the Commonwealth's case was totally lacking. We have done post-conviction the investigation that the government should have done if it wanted to drill down and really find out what happened the night this woman died. Right? What they've done is say, well, we've got our guy, we have people who say he did it, and we're not going to disturb this apple cart by going to look in this pond, by talking to Nizzolillo more. We're not going to figure out what kind of gun might have fired this mismatched fire. We're not going to ask any questions about why our victim was shot in the face and does a bullet that just goes here and just basically punches through her cheekbone and stops. Right? That's a very bizarre fact. We've all dealt with firearms cases. It doesn't make any sense until Louis Gordon comes forward and says, well, a mismatched fire only came out at 200 feet per second, 70% reduced velocity. Dr. Labasada says, well, that's consistent with what I see in this autopsy report. Dr. Hull, the state's medical examiner, really doesn't have any interest in talking about anything, right? I can't say blah, 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 right? I mean, again, I know the medical examiners just stick to their report. But the bottom line is you bring in Dr. Labasada, also a former medical examiner and a very well-respected pathologist, and she takes one look at it and says, here's exactly, you don't need to examine anything to know that when a person is shot here or when you have this blow here sufficient with the force to break your cheekbone, there's going to be a tremendous amount of pain. It's vascular and dense. There's going to be blood flowing in. You're going to be choking almost immediately. There's absolutely no way that anybody could talk to you on the phone and think you were normal joking around. When Tom Hogan signs off on that part of his testimony, he says, the trial, of course, because he has to introduce this to incriminate the defendant while also making himself look not guilty, right? So he says, oh, yeah, no, she was fine. She was joking around, so I just hung up and went home, right? That's the person he just spoke to on the phone, supposedly, who's just been shot in the face. I mean, what we're really, I know I'm way over here, and I appreciate all the time because there's just a case with a tremendous amount going on. But what we're really about, right, and this is like a 33E relevant question, is like we're just at a fundamental fairness zone here. Like this is the end of this man's life in prison without parole, convicted of first-degree murder. And this is the level of both egregious Brady violation, willful, both in terms of non-disclosure and failure of inquiry, leaving us completely out there. Like there is no way he has any access to this information without the government simply. And we know what else is amazing. I mean, since you're just letting me go on.
This is going to be your last thought.
Sure. The trial prosecutor says he received a call. So he obviously did receive the Richardson email, but he also received a call from his federal counterpart, the AUSA on the Nizzolillo case, to inform him that the AUSA Abley had received information in the Nizzolillo proffer relevant to this state murder case. So at that point, he doesn't even just say, could you just send me the report of the proffer? I mean, again, and then he's standing there while trial counsel is saying, he's feeling his way towards, wait, Billy's involved in this much deeper, Judge, and the trial prosecutor is just not saying a thing. I mean, that's just fundamentally unjust.
Thank you, Mr. Schnipper.
I'll rest on my brief. Thank you very much.
Attorney Herron, please.
Good morning. May it please the court. Assistant District Attorney Donovan Herron on behalf of the Commonwealth. The Commonwealth is here conceding that the prosecutor should have disclosed to the defendant prior to trial the limited information he knew about that 2018 proffer. We are not suggesting otherwise. What we asked Judge Wren to focus on, and what she did, and which I suggest he did not abuse his discretion, is whether the defendant has established prejudice in the failure to disclose this information. And given the overwhelming evidence of the defendant's guilt at trial, which Judge Wren was well aware of as the trial judge, the lack of credibility of the information, I'm going to call him Vito because I also have a hard time pronouncing his last name.
I should know how to pronounce his name. But the other part of it is, what's the linchpin of Judge Wren's findings on lack of prejudice? Because we have this bizarre factual pattern, many moving parts with different parties and shifting alliances and motives. And we have, as Justice Stewart pointed out, the telephone conversations, but the testimony and the third-party culprit stuff pointing to Billy seems relatively significant in that it's compromised heavily by the federal informant. So give me what the linchpin of Judge Wren's decision was on prejudice.
The overwhelming evidence against the defendant and the lack of credibility of that information, if I may take some time to explain it. First of all, for the overwhelming evidence, we have Hogan, who does not know and there's no connection between Billy and Hogan. We have Hogan, who says that he sets up the murder for hire. He drives the defendant there. The defendant says, I think I want to try to have sex with the victim. She's kind of cute. He drops her off. We have the phone records that corroborate that Hogan was calling both the defendant and the victim constantly saying what's going on. We have the victims.
But isn't Hogan compromised because he could be a suspect? Please continue.
He does. And that was fully vetted in front of the jury. Hogan definitely lies to the police when he first talks to them, and he definitely is trying to hide. But we have, they search Hogan's car and they find gas receipts and stuff that do place him at different places around the time that the defendant is with the victim. We have then the victim calling Hogan and saying, I was just shot. He groped me and he shot me. And then we have him showing up at Billy's house. We have the defendant showing up at Billy's house, saying he just hemmed up a stripper, meaning, which Billy testified that he just killed the stripper. We have Miss Thompson, who also arrives at Billy's house. We have Miss Thompson, who testifies that she sees.
But both Thompson and Hogan are potential, they're deeply implicated in this. We've got
disagree
Hogan.
with that.
Hogan helped set up the murder,
Yes.
according to Hogan, and Thompson helps conceal the murder.
Yes.
So they're both not the world's. We have no neutral witnesses here, right?
Well, then you have Joe O'Grady, who testifies that he comes and picks up Billy at 9 o'clock, and you have Miss Thompson corroborating that, saying she does see Mr. O'Grady picking up, and he says he drops the defendant, he drops Billy.
Better slow down.
I apologize,
Okay.
Your Honor. We have Joe O'Grady testifying that he picks Billy up from his house around 9 o'clock. We have,
What does that show?
if you give me one more second, we have him testifying that he drops Billy back off at midnight. We have the 911 call for the fire of the burning of the thing coming at 10:30. So he has the time that the car is set on fire, which Ms. Thompson testifies to. We have Billy with Joe O'Grady at his apartment from 9 to 12. And we have Ms. Thompson corroborating that part that she sees Mr. O'Grady picking Billy up at his house around 9 o'clock. We have her testifying that she goes with the defendant to Swan
Okay,
Ave.
again, you're so deep in this. I'm not as deep. So
I
the
apologize.
car is burned at 9 o'clock. The car is reported being burned sometime around 9 to 10 p.m., right?
Yes, the 911 call, I believe it comes in at 10:30 from the Worcester Fire Department, responds to about a burning, the victim's car being set on fire.
So you're saying because this guy, Bill O'Grady, says that he's with, Joe O'Grady, or whatever his name is, he's with Billy around that time, therefore there's overwhelming evidence that Bill, and do we have phone records or anything objective that confirms that, or just the testimony of Mr. O'Grady?
We have the testimony of the witness of Mr. O'Grady, and then we have the jailhouse informant, Mr. Millett, that testifies that the defendant confesses to him in jail and asks him to call Ms. Thompson to get her to not testify and assert her fifth. As soon as he gets out of jail, we have her and Ms. Thompson both testifying to the phone call that he makes to her, that he tells her it's best if she not testify, that she should assert her Fifth Amendment privilege. She testifies she receives a phone call from someone she doesn't know who says that exact same thing, that she shouldn't testify, that she should assert her Fifth Amendment privilege, and she should keep her mouth shut. He testifies that the defendant confessed to him that he did kill the victim. And then we have the phone records, which suggest that. And also, Mr. Nuzio, I'm going to say Vito because I know I'm going to mispronounce his name, I apologize. We have him saying one of the key pertinent facts was he left the door open when he claiming Billy burnt the car. And we know that that's not true because we have the Worcester Fire Department testifying that when they came into the engulfed car, they opened the door was shut. It was not open as.
The hemmed up a stripper, that was told to Billy though, right?
Billy, yes.
Right.
And then we have the defendant threatening Billy, we have the defendant threatening Hogan, and we have the defendant threatening Ms. Thompson to keep his mouth shut. And we have his cell phone being shut off around the pertinent time of being dropped off and the car being burned.
Yeah, I think Mr. Schnipper's point is, okay, you may have a better story, but when the prosecutor fails to turn over basically a witness who's going to be a third party, is going to point the finger at someone else. And, you know, you got a messy story to begin with. He gets to present that to the jury, or it's just, you know, the jury's got nothing besides that. I mean, it seems compelling when you've got such egregious or at least strong Brady violations here.
I just don't think we have anything of substance from Vito. And we don't have an affidavit from him saying, I would have testified.
Thing I didn't understand, Mr. Schnipper said that he did a follow-up, that I can't remember the exact terminology, that he adopted. We've got something that indicates he adopted the proffer. I haven't read that yet. What is that? What is that?
So I want to go back to the time of the 9th day of trial. The first thing Judge Wren says is, where's an affidavit from this Vito? And his counsel, Mr. Ryan, says, oh, I can get one immediately. I can get one now. And he's like, well, I'm troubled by there's no affidavit. That's in 2020. I filed my opposition, I think in 2022, pointing out there's still no affidavit from this Vito saying what he would have testified to. And keep in mind, this Vito faced mandatory minimum 10-year federal drug sentencing and was only trying to leverage this to try to get a reduction of sentence. So we have that as well going to his credibility.
And we got all.
And so then
there isn't a credible witness in the case, so I get
well, I
it.
disagree with you. I respectively disagree
So
with you.
who?
Can I ask
Go ahead.
a clarifying question? On, when Millard testified, the jailhouse informant?
Yes.
How was he cross-examined? How was he challenged by the defense?
You know what? I got to be honest with you, Honor. I don't remember.
I'll look for it. Thank you.
I apologize.
That's all right.
I just don't remember how he was.
Okay.
I think just that he's not believable. I know he argued he wasn't credible, but I don't remember his exact cross-examination of him.
Yeah, we'll look at it. Thank you.
Go ahead.
But and as the trial judge, Judge Wren was well aware of all this evidence that was against the defendant and the thing. And lost my train of thought. So then after my opposition, in which I pointed there still was no affidavit from Vito at I think it was the hearing on the motion to decide whether there should be an evidentiary hearing. It's the first time I'm handed an affidavit, which is, I suggest, not of substance. It just simply says, everything I said in the proffer I'm sticking to is true and accurate. And quite frankly, I think Judge Wren would have recognized that he's stuck in a box here, because if he doesn't say that, he could be facing issues down the road with the feds if he's admitting that he lied to them. So given all that we don't have an affidavit saying, today, I would...
If you'd had an evidentiary hearing, all this could have come out, but you don't have an evidentiary hearing which you oppose.
I did, but I just want to note for the fact that my brother did not say he wanted Vito to testify at the evidentiary hearing. He actually said the opposite. He said, I don't think I really need him. I would like Sergeant Richardson to come up here and be so indignant that we didn't have an evidentiary hearing with Vito when he didn't request Vito testify. That wasn't on his list of people he wanted to testify. I think is a little disingenuous here, because he specifically said he didn't think he needed him and just wanted defense counsel and his two experts to testify, and maybe Sergeant Richardson. And those are the people he requested.
I assume we can look at the post-conviction request for a hearing to see whether or not.
November 21st, I have the transcript right here where he specifically says he recognizes it will be difficult to get Vito here, and he, quote, doesn't think he really needs him. And the four people he wanted were his two experts, defense counsel Mark Shea, and Sergeant
Richardson.
Detective Mark Richardson. Those are the four people he requested for the evidentiary hearing. And the Commonwealth argument as to the two experts was, even if you accept everything they say is true, they don't entitle the defendant to a new trial. So we argued it wasn't necessary to have an evidentiary hearing versus the two experts. And also, we weren't challenging anything that Mr. Shea was saying in his affidavit. So therefore, that was our argument as to why an evidentiary hearing wasn't necessary.
You don't think it's significant that if you posit what the former Rhode Island medical examiner says, is that you presented incredible evidence to the jury that someone could speak after being shot in the face?
She does not, if you read her affidavit, it does not say, she actually says she'll be able to talk. So I would agree with you, if her affidavit said she would never be able to talk, which was the Neves, I forget the name of the case, Rodriguez-Neves case, that would be difficult. She actually says, I believe she would have been conscious and able to talk. I just don't think she'd be able to talk normally. I don't think that gives the defendant a very substantial ground of defense there, because she's not testifying she could not talk at all. She's saying she actually thinks she could talk. She would have been conscious. It's just she wouldn't have been talked normally. So then you'd be trying to cross-examine Hogan on what does he mean by normally or jokingly, and I just don't think that provides a substantial ground of defense or
And
would have been a
Hogan's-
real factor in the jury's deliberation.
And Hogan's statement comes, is the key witness, and the day before trial, we get this major new information from him.
We do, which was immediately turned over by the prosecutor. As soon as he learned of it, he gave it to defense counsel. And defense counsel, that's on the record on the first day of trial. Defense counsel says immediately that Mr. McLaughlin had turned this over to him as soon as he had gotten it.
Hogan or Thompson testifying pursuant to some cooperation agreement, or?
No.
Okay.
And they all corroborate each other's testimony, which is also, the cell phone records also corroborate Hogan's testimony as to the phone calls he received and regarding, real quick, the first issue, I didn't argue this in my brief, and I did just want to quickly say for the motion to suppress the search warrant, I would suggest even if this court were to find, which I do not concede that there wasn't probable cause, the information would still have been admitted through Hogan's cell phone records and Hogan's testimony, because this is the defendant's number, and because he testifies how he knows the defendant by the name Oz, that the defendant has that tattooed on him, and all the communications between the defendant and the victim and Hogan would have come in through Hogan's cell phone records and Hogan's testimony. So I did not argue that in my brief, and I do want to raise that point. I thought about it as preparing for oral argument, that even if this court were to conclude that the motion to suppress the search should have been allowed, Hogan's records would have still come in and would have still implicated the defendant, because all the communications which Hogan testified to at trial would have still been admitted.
This idea that someone told the prosecutor that it wasn't a Brady violation, I understand the U.S. Attorney's Office denied that, right? Is there any basis for it whatsoever? When we go through the record, what are we going to discover about that? That she says somebody tells her it's not Brady, which may be meaningless anyway, but I'm just trying to understand, is there some good faith basis for that we're going to find in the record when the U.S. Attorney's Office says we didn't say anything of the kind?
First, I don't think you have that from the U.S. Attorney's Office.
I thought
It's a male person.
Denial, yeah.
It's a male prosecutor, and he, at the time of trial, when the motion to continue was brought up the 9th day of trial, he says, "This is what I know. This is my limited information," and I think he repeats it at the first motion for post-conviction discovery. And he did file another motion to clarify what he meant.
I thought he said the assistant U.S. attorney said something like, there's no Brady violation here. And then the assistant U.S. attorney says, I didn't say anything like that.
No, that's not what we have. The prosecutor, does say that it was, I have the transcript right here. He does say something like, I can tell you what I know, the limited information I know about this, Your Honor. And he talks about that he,
I don't know, I remember reading something in the brief on this, but again, it was a lot of briefing late at night, so I'm not.
Let me ask you, the judge is finding that the information was not in the custody control of the Commonwealth, notwithstanding the email, is erroneous, correct?
I respectfully disagree. No, Vito is not our witness. We
No.
do not have immunity agreement with him. We don't have a proffer with him. The federal government did the proffer.
No, but the information, the feds take that information, they pass it along to a Worcester detective, correct?
They had a discussion with him about what they gathered, and I admit that what they discussed.
So as soon as a Worcester detective the Worcester detective is a member of the prosecution team, correct?
Yes.
So the information is in the custody of the Commonwealth, right?
That information that was told to him, yes, and I agree that that should have been disclosed prior to trial to the
Yeah,
defendant.
whether it's the report versus the information is a red herring. It's the information that's exculpatory, correct?
Yes, but I'm just saying the physical report itself, we did not have
Whatever. but
access
you
to. But
still
yes,
you still have information
I am conceding
saying-
that information that was received, which again, because of Mr. O'Grady giving Billy an alibi, the fact that all the information known at trial, Ms. Thompson's testimony.
Was the judge's finding just focused on the report as opposed to the information as far as custody control?
No, he found that the information that even if the veto, Judge Wren's finding was that he did not find veto credible. That the information contained in the report he did not find credible given the evidence at trial, which he found was overwhelming. for the reasons I've stated, given Mrs. Thompson's testimony, given that Hogan's testimony, given Mr. O'Grady's testimony, given an alibi.
That's two different concepts. There's a credibility determination and there's a prejudice determination. How is he assessing credibility without the person's testimony? I get the circumstances that he's desperate, he's about to be sentenced. There's that. Is that why he says he's not credible?
Yes, that's what he says first at the motion to continue, and then again in his findings on the motion for new trial. Because at both times, he's facing federal sentence. He also finds he still doesn't have an affidavit of substance from Vito, which says, I today will testify to the following, even though I'm now sentenced, and I think I put it in my thing, to 11 years and 8 years supervision. Even though I've been launched by the federal government, I'm still willing to testify to all this. We don't have that.
I take it that the affidavit is short, but it does say, I was provided with this DEA report regarding, I have reviewed this report. It accurately describes my statements to the agents during the proffer about what Billy McEnany told me about his own involvement in the Marie Martin case. Those statements are true. If I had been called as a witness during the trial, I would have testified consistent with the statements described in the report. If I am called as a witness at a hearing on the motion for new trial, I will testify consistent with the statements described in the report. I mean, it's not a fresh set of statements, but it does completely adopt and say that he would testify to those statements. Is there case law suggesting that that the judge can discredit the affidavit because it doesn't include the statements?
I don't know of a case off the top of my head, Your Honor, that says that you can do that. I just think common sense-wise that Judge Wren, given that we were inquiring about an affidavit since that 9th day of trial, and then after my opposition, and then it's another 8 months after my opposition is filed that I'm handed this affidavit. I think Judge Wren could take into consideration in determining whether he believes this warrants a new trial, given the evidence at trial, given the credibility issues he deems with the information that we do know that is provided, that is directly contradicted by the evidence at trial. So I think he can take all that into consideration in that it is not, and it's not an affidavit of substance, that still would not have been a real factor in the jury's determination, which is the end of the day what he was to determine, whether the defendant was prejudiced by this lack of disclosure of the information that the prosecutor knew at the time that he didn't disclose. And I think he was well warranted in concluding it would not have been a real difference in the jury's determination and in the jury's verdict, which is what he was asked to do under the motion for new trial. And I suggest this court should not find that he abused his discretion and to affirm the order denying the motion for new trial and affirm the conviction.
Okay, before you run away, though, so what I was talking about earlier, I'm reading from Mr. Schnipper's brief. In April 2021, Goparian filed a motion for discovery relating to Nozzolio's proffer session, Worcester Police Department participation in, and the person who purportedly told the trial prosecutor Nozzolio's proffer was not Brady material. When prompted at a hearing to disclose this person's identity, just lost it. The prosecutor claimed, I had a conversation with Assistant U.S. Attorney William Abley. 5 days later, the prosecutor wrote to the court to clarify that although Attorney Abley was the person he called to inform me that he had received information, at no time did he characterize the information as not Brady material.
Yes.
So is there anybody out there that characterized this as Brady material, not Brady material, or is this, what do we do with all of this?
On the record, we have him at the 9th day of trial saying that I found the transcript. I believe, I'll tell you what I know to the judge, and he's like, I believe there's a federal proffer with the feds in 2018. I don't know the individual. I'm assuming it's the same individual we're talking about right now. I know they found him not to be credible. That information was passed to me, and it was represented to me. They did not believe it was Brady material. I believe he was wrong when he said that. And so when he filed that second letter or thing saying, I want to clarify, he was wrong when he said that USA Abley was the one that said that to him. He wanted to clarify that. I don't know if anyone specifically said to him, but what he knows is the information that was passed to him was not found credible, and that was backed up by the evidence at trial and the And that's what he believed mistakenly, and the Commonwealth is conceding. He should have disclosed it, that because it was not deemed credible, he didn't have to turn it over. That was an error. That shouldn't have happened. He should have turned it over. We are conceding that, but what this court has to determine is whether the defendant was prejudiced because of this, and I suggest, as Judge Wren found, basically the lack of credibility of this information and the overwhelming evidence of the defendant's guilt, which you can knock each of these witnesses, but they all corroborate each other and they all don't know each other. So it would be a different thing if Hogan knew Billy or Hogan knew Heidi or they all knew Thomas Millett, but only Hogan and Thompson seem to know each other inferentially, and they all know the defendant. The defendant is the key player in all four of these witnesses. So based on all that, and being that Judge Wren was the trial judge and knowing, seeing the evidence at trial, I think I ask this court to affirm his order denying the motion for new trial and affirm the defendant's conviction for first-degree murder.
Thank you, counsel.